Good afternoon, and thank you for joining us today. I would like to welcome you to FortneyScott's Employer Briefing. These monthly briefings address COVID pandemic-related updates and other developments affecting our society, including the Black Lives Matter movement, as well as key judicial, legislative, and policy changes. This briefing will be recorded. Everyone who registered today will be registered for all future employer briefings. I want to address some preliminary items before we begin. Currently, all listeners' phones are muted. At any point in time during the presentation, please feel free to submit a question in the GoToWebinar question box. We will try to answer all questions. Today's briefing will address the latest developments affecting employers operating during the COVID pandemic, the newest challenges employers are facing as part of the broad-based focus on discrimination in America, and key legal and federal agency developments. The presenters are FortneyScott attorneys David Fortney, Nita Beecher, and Bert Fishman. I will now turn the program over to David Fortney to start our briefing.
Terrific. Thank you, Valerie, and greetings, everyone. We're really delighted to be with you today, Monday, October 19th. There's so much going on, and there's been so much going on since we last had the opportunity to speak to you approximately a month ago. Both Bert and Nita, it's great to see both of you. And of course, we all, like most of you, continue to work virtually and present virtually. But that just because we're virtual doesn't mean there's not a lot going on. So let's jump right in. Let's cover some of our preliminary matters. Just a word or two about who we are. I think as most of you know, we are a law firm. We're based in Washington, D.C. Our practice focuses on counseling and advising employers. We do represent regularly employers, federal contractors, and others before a wide range of federal agencies. We also spend most of our professional efforts dealing with federal compliance programs. That includes statutes, regulations, and particularly for today, executive orders. And so we're going to give you the latest on that. Let's go to the next slide, please. Just a housekeeping note that although we are lawyers and most of what we're talking about do involve legal updates, we of course would encourage and remind each of you that today's briefing is for information purposes only. We are not providing legal advice to anyone. And that we would encourage that you confer with your corporate counsel or with experienced outside counsel in order to secure advice about how these developments may affect your specific circumstances. All right. Well, let's start with the rather benign question. So, what has happened since we last met? And I think, as we say almost every time, a lot. But let's bucket out. Let's look a little bit at our agenda on what we'd like to spend our next few minutes with you on. Obviously, there continue to be a number of COVID-19 related developments that directly affect the workplace, and we want to discuss those briefly with you. Uniquely, in this cycle, we have President Trump's third Supreme Court nomination with Judge Barrett. Talk a little bit about not so much the nomination, which I think everyone knows, but what the impact may be with respect to employers, how we anticipate that will affect the issues that employers are focused on. With respect to social unrest and Black Lives Matters, there have been a number of developments, including involving diversity and inclusion training, with the new executive order and a number of cascading events relating to that we do want to focus on. And finally, the federal agencies, with all that's going on, they're also part of the developments, and there are a number of key developments there. So, an enormous amount of material to cover. We're going to be mindful of our time. And Nita, I'd like you, if you would kick us off, please, on the latest on some of the COVID-19 developments.
I'd be delighted, David. Valerie, thank you. I think everybody should take a quick look at this slide. We are now at, this past week, we had 55,000 new cases averaging a day, On Friday, we had 70,000 new cases. Most of these are in the Midwest and the Plain States, so the upper Midwest as well. And that is going to impact lots of things, I think, David, as we move forward. And so, Bert, do you want to talk a little bit about COVID relief? Do we see any help for employers and people?
As we can get to the next slide, that might help us focus. But frankly, this is one of those rare moments of bipartisanship in this partisan time. Most people feel it's a pox on both their houses. Frankly, the presidential vacillation on this issue has been one of the biggest stumbling blocks. You may recall in this past week even, there was a cessation of negotiations, a reinstitution of negotiations, the Senate Republicans rejecting the large bill that the president offered, then finally the go big or go home. So it is not too much to say that the president and the Republican leadership are at loggerheads, which gives the Democrats an opportunity to do nothing and let them fight among themselves. The upshot, unfortunately, is that we do not appear to have a bill that will be passed before the election. Speaker Pelosi announced yesterday that unless it's done tomorrow, there's simply not enough time to get a bill through before the election. We anticipate that a skinny bill, half a trillion, which only in today's world is considered skinny, is going to be offered by Senator McConnell. It is probably not even going to get support from the Republican caucus. And the real problem is that there's just not enough time to get stuff done. The specter haunting this entire process and the way in which the election seems to influence even response to the crisis is that if there's no bill before the election, there is little incentive to create a bill after. Either the Republican caucus won't have it, or the lame duck Republicans don't want it because they will, in that sense, not want to assist the new administration. And the dire consequences of that, and that's why there's a pox on both their houses, is that people in need will continue to be in need without federal relief, perhaps until February. On a more positive note, we do have a continuing resolution that kept the government open, but that will only be for a month after the election, and that will be one of the first knockdown, drag-out battles if there is a change in the constituency of the Senate and of the House. But for now, all we can say is they didn't get it done.
Right.
It wasn't just Mnuchin. Nobody brought home the bacon.
Well, but I thought it was interesting because at one point we had the Senate Republicans on one course, the $500 billion. We had the White House on a different course, and then we had the Democrats led by Speaker Pelosi. But more recently, President Trump has appeared to veer off on his own course. He has been demanding that amounts greater than Speaker Pelosi of $2.2 billion. Mnuchin is somewhere around $1.8 trillion. So keep in mind, we now have the lead negotiator from the White House at one number. We have the president at a different, much higher number than anyone. And then we have the Republicans who are necessary parties at the $500 billion. I mean, it is wildly dysfunctional. So we have now a kind of a four-way negotiation between the president, his own Secretary of Treasury, Mnuchin, as well as Pelosi and McConnell. So I think that your point, it does suggest lame duck is likely to be fairly active on these matters. Whatever the outcome of the election, the lame duck Congress is not going to not just go home. They will be very active.
You know, I am not one who comments on the effectiveness of the Senate, but frankly, in the space of a week, the president went from "I'm stopping negotiations entirely," "No, I want something," to "go big or go home," so that it's quite fair to say that the Republican Party, taking its lead from the White House, doesn't know where it is. And it's a kind of a tragedy for everyone.
Well, So we have that challenge, and it best we can tell, the next 24 to 36 hours will tell whether we get a COVID bill short run or not. But we also have some additional new challenges. And Nita, do you want to talk about some of those, please?
Sure. Let's go to the next slide, Valerie. Let's talk about, employers are continuing to face new legal challenges. Many of the employees who are ill are trying to find, or who are afraid of being ill but have to go to work anyway, are trying to find the ways around workers' comp and other restrictions, including many new liability states are enacting, safe harbors for employers so that employees can't sue them and neither can customers. However, employees are getting, or and I should probably mention plaintiffs' counsels are getting very creative. And I think the most interesting one that we saw just was filed in New Jersey. You had the CDC and other people have recommended that if you have people in the workplace, you make sure you have someone who enforces the rules. And an employee that was in that position in New Jersey for Amazon claims that he was fired and has filed a whistleblowing lawsuit under the New Jersey whistleblowing law, saying he was fired by telling one of the leaders of the site where he was that they weren't following the protocols by turning him in. And so the employee is alleging that he was fired for doing his job. I think this is going to be an interesting problem as we move forward, where if you do bring people back into the workplace and you insist that they follow the protocols of social distancing and contact tracing and so forth, that you make sure that your senior management is following the rules, or the employees that are being, the employees may be able to file state whistleblower lawsuits. There are also a number of lawsuits all over the country. There's a McDonald's lawsuit. There are lawsuits in New York around employees not being properly protected. I think we're going to see a lot more of those. We have not seen, surprisingly, more collective action as we saw early on, but they seem to be going to litigation rather than that. And so the other thing is, another issue that's being raised is employers moving employees back to pre-COVID standards as far as how quickly you have to operate and that type of thing, which is a problem if you are 6 feet apart and people are wearing masks. Any other thoughts, David?
A couple things. Your comments on the legal safe harbors and the growing claims. A month or so ago, 6 weeks ago, seems like a long time ago, longer than that, but Majority Leader McConnell said that as a condition of further COVID relief, there would be some form of safe harbor enacted. It was a condition, and of course, the speakers, the Democrats' response was basically drop dead. We'll never agree to that. So many states have continued to enact safe harbor, so we're getting that patchwork scenario growing. Number two, as the federal OSHA has continued to dig in and rely solely on the general duty and not promulgate a OSHA standard on COVID, we now have the second state. First was Virginia. Now we have Michigan that has just enacted a new specific standard. Because I think all these pieces fit together. They start to define what an employer must do with greater specificity, to the extent that there are OSHA or other state law requirements that are more detailed. If you violate those, it will provide also causes of action or enforcement means. If you don't have those in place, it's more likely that these more far-reaching whistleblower, more generic, potentially common law claims, primarily under state law, may start to haunt employers. But I think that's going to continue to be the pattern, an accelerating pattern, I might add, as that chart that we looked at to begin today, as the infection rate continues to escalate.
David, I'll just point, it may be a poison pill, but Senator McConnell is going to have an employer liability clause in the skinny bill that he purports to introduce this week.
Right. And you're right, Bert, whether it's intended as a poison pill or not, it will have that effect. because it is a non-starter. And of course, going back to Civics 101, it could be negotiated away if both houses of Congress would pass bills with conflicting provisions. They could conciliate and reconcile, reconciliation conference. And so it's possible, but boy, it doesn't feel likely as we sit here today.
Not enough time. They're going to go out on Wednesday to campaign. That's the end of it.
Right.
Well,
so let's go to the next slide because I'm sorry, David, go ahead.
Go ahead. No, go ahead.
Yeah, I was just going to say it's really slowed down. I think the most important thing on this whole slide is that 73% of Americans fear being back in the workplace, that it could pose a risk to personal health and safety. 73% is an incredibly high number of Americans who are afraid. And we know, I just saw a stat that said that people go to restaurants and bars, that's where you get COVID now. It's indoor stuff. So, and what we're seeing happening is that the offices initially that were closed in March, like ours was, companies expected people, and I think David and Bert, we all felt that we would be back in the office shortly. Now we're in a situation of, they said October, January, now we're July of 2021. And a lot of companies, the tech companies in particular, are instituting permanent work from home for employees that want to. There is a catch, however. There's always a catch, because many of these people were in very expensive places to live, San Francisco and south of San Francisco. Those who are moving someplace cheaper, and I just saw something called Zoom towns that are being set up outside of ski resorts and other fun places. My best friend, for example, they have a place at the beach. She goes to Hilton Head and is working from Hilton Head, which I envy greatly. Anyway, they are cutting people's salaries, however, which I think is going to be interesting as we move forward. You know, what that's all going to mean. And the whole salary, a lot of these salary cuts, I don't know that employers have really thought about pay equity and some of the other issues we deal with. But nevertheless, meanwhile, Christmas is coming. We've got all the holiday seasons coming up. And interestingly, I just saw that retail employees are receiving training in how to manage fights over mask wearing, social distancing, store capacity. I was just at a Containers, I just moved, so we're still organizing. I was at a Containers and More store, and we were outside. They can only let in so many people. So on a Saturday afternoon, you know, you stand outside, and in a few months living in St. Louis, it's going to be kind of cold and snowy standing outside. So, but the idea that you have to train your employees and how to de-escalate situations with mask wearing is really a little scary to me. David?
Yeah.
Well, I think, there were, I mean, there's a lot in those developments. I think this one about the localized pay, though, is one that a lot of people are not thinking through. And I think, Nita, the point that you made is a really important one, that as compensation systems have been developed and they've had, you know, typically a geographic component, so that if you're in a higher cost area, you value the job typically, and then if you're in a higher cost area, you may reflect that if you're in San Francisco or New York City, et cetera. But the value of the job, presumably, most of these jobs haven't changed, so the value contribution, the market may still be the same, but the companies are saying, well, gosh, if you want to go live with grandma in Oklahoma, we're going to pay you a lower wage. Right. Sometimes it's 10%, sometimes it's significantly more. So they've pulled out and dusted off geographic maps. Right. And so people, and now many people, and this is the power of having a job during pandemic, and I think the employer does have the discretion, you know, the bargaining power on this, says, look, if you want to move, that's fine, but we are going to cut your pay. And I think increasingly most people say, fine. How that plays out, if that ultimately, I mean, I could see a challenge if that's done on a widespread basis, or depending on who are making those moves, what the impact is. I'm more comfortable making pay adjustments, certainly based on productivity. If individuals say, look, I now can only work 2/3 time because I have to take care of family members who are going to school
Right.
from home, etc. I get that. But this, I think, remains to be seen. I might add that there are further complications, even including the new California pay reporting. Who gets reported as California pay? We deal with a lot of folks in California. And there's a new state law requiring reporting on your, quote, California employees. Well, what is a California employee? Used to be where they would go to the office. Well, if you're working in Utah, reporting in to your boss who's based in California but working in Massachusetts, are you working in California? I don't know. But these things, these issues are becoming murkier. And again, another example of a trend accelerating legal standards that we had in place that worked reasonably well, feeling like they're not quite going to work as well as those changes roll out.
Quite true.
Anything else on that? Because otherwise, I want to save a few minutes.
Well, I think that's enough because we want to talk about Amy, Judge Amy.
Yeah, the infamous. She has her own hashtag, I guess, ACB. I don't know if she's notorious. I don't think she could take that moniker, but
really,
Bert, why don't you offer some thoughts?
I'll be happy to.
About Judge Barrett's confirmation.
Senator Leahy, who has probably been present for the confirmation of every sitting member of the Supreme Court, commented to nominee Barrett that she is likely in the most difficult situation of any nominee and any new justice, largely because of the repeated explicit expectations from the president regarding Obamacare, regarding Roe v. Wade, regarding even the election. And it's been just terrible to think about the kind of burdens the judge will face, no matter how she rules on any of these, in favor, against. It'll all be seen through a horribly partisan prism. And to some degree, she has brought some of that on herself by raising the refusal to answer questions to a degree of almost comic proportions. The one that's getting the most play, of course, is asked about climate change and coming with the line from Breitbart, "I'm no scientist." That rippled through the entire community quite quickly. But more importantly, from our point of view, as the coalitions on the court change, the impact on employment-related material is probably not going to be that great. This has been a very pro-employer court with respect to issues whenever they've come up with them regarding employer liability, regarding certain regulatory matters. And it appears to me, at least at any rate, that if the new court has to rule on things like independent contractor or joint employer, what would have been a 5-4 decision will now be a 6-3 decision. On the more difficult Administrative Procedure Act, where the regulations are listed or not, another textualist, a la Judge Gorsuch, may cause some surprises for some people on the right side of the political spectrum who are expecting a kind of rubber stamp response, and they may be surprised, just as they were by Judge Gorsuch and the Bostock decision. But generally speaking, on the more run-of-the-mill employment matters, we can expect 6-3 decisions where we would have had 5-4. The more interesting cases are the more politically charged ones, and no one envies Judge Barrett her position because of the nature of this confirmation and the speed with which it took place. There's this great line from Hamlet where he's complaining that the funeral table became the wedding feast, and that's real close to what happened here. And we wish her well, but it's a strange situation.
I think there are two things. Number one, Justice Roberts, that has enjoyed being sort of the swing justice and has been able, I think, to influence a number of decisions and outcomes, likely loses that role or has to certainly modify his role. And so the Roberts Court, which has literally very much been the Chief Justice, may look a little different going forward. Number one. Number two,
I would say that the biggest difference that's going to change is the influence of the chief.
Yes, agreed. Second, the Affordable Care Act, which I think everyone had assumed that Judge Barrett would be responsible for striking down. Who knows? But she at least gave one or two interesting, somewhat nuanced answers on severability. And you saw all the senators involved on the Judiciary Committee trying to parse what that means. But it at least suggested that perhaps she might be amenable to knocking down certain portions of the statute and leaving the rest in place, which of course is what the Chief Justice was effectively able to do in some of his earlier rulings that allowed ACA to continue. So it'll be a game changer. She will be confirmed. She'll be confirmed before, right on the eve of the election, and we'll go from there. All right.
There was just quickly on the ACA. Many Republican senators on the committee kind of saw this issue slipping away as an election issue. And at the very end of her nomination hearing, it was a series of quite literally softballs on, isn't there a doctrine of severability? Isn't it the role of the courts to try to preserve a statute? And the answers to those were obviously yes, but the credibility of those responses was widely challenged.
Correct. So, we will see, but we will see before we get together next month. We will have some of these answers in place.
Probably.
Well, let's pivot to Black Lives Matter, which continues to be a very robust area, particularly as affecting the workplace, some of these social trends. And fortunately, we don't seem to have as many demonstrations actively impacting things as we've had in the past. But we have a number of other changes that are beginning to take shape that really directly impact the workplace. And we want to talk about some of those and unpack some of those developments for you. So let's dive in the next slide, Valerie, please, and talk a little bit about a response that has been rolled out by the administration really over the last 5 to 6 weeks. And it deals with whether diversity and inclusion training is proper and plays a proper role. I think most people thought that was pretty well set. As is often the case, a pundit was interviewed on Fox News. He articulated an opinion that there was a lot of mischief going on under the banner of diversity and inclusion, and improper, targeted, and actually discriminatory training was occurring. That then resulted within 24 to 48 hours on Friday of Labor Day weekend of the Office of Management and Budget issuing a memo to all federal agencies indicating that sensitivity training that was divisive and un-American was to be discontinued. And unpacking that a little bit, it was about topics such as white guilt, white privilege, the training that was focused on that, and there were some examples provided. Shortly thereafter, the middle of September, September 22nd, was Executive Order 13950 that has become rapidly publicized and has raised a whole host of concerns that we're going to talk about. But basically, it directs that federal contractors and federal grant recipients are to stop divisive workplace training, which again deals with certain types of diversity and inclusion training, some of which involving implicit bias and so forth is very common and widespread. And then finally, the third major component that has occurred is at the end of September, September 29th, the Office of Management and Budget issued a specific memo detailing for the agencies how they were to go about implementing the directions that were contained in the new executive order on diversity and inclusion training. And specifically, the federal agencies were directed to do a word search of all the training that was being offered, either by the agencies themselves or their contractors, and to look for specific words such as implicit bias, white privilege, and other words like that, and to use that word search in order to help identify portions of training that may be prohibited by the executive order. It instructs further that you're to look more broadly at the context. It wasn't just searching out the prohibited words, but to do that. So those have sent the, it is shocking, because it's shocking that the federal government is prescribing speech content that can be articulated, and we'll talk about that a little bit. And it raises a number of questions as far as remedies, and we'll talk a little bit about what may occur. Well, let's dive in a little bit and talk about what's actually in that executive order, because that's kind of the central element of these developments. And,
right.
And Nita, could you lead us on that, please?
Yeah, I'd be delighted to do that. Let me just read you one sentence that I think epitomizes what we're dealing with in this executive order. In the preamble to the executive order, there is this sentence: instructors and materials teaching that men and members of certain races, as well as our most vulnerable institutions, are inherently sexist and racist, are appearing in workplace diversity trainings across the country, even in components of federal government and among federal contractors. So the focus of Executive Order 13950 is certain types of training which this executive order believes picks on whites and men, I believe. There are a number, as David, you mentioned, including critical race theory, which I think is another one, the New York Times 1619 project as well. And these divisive, I'm sorry, go ahead.
No, go ahead.
These divisive concepts are outlined in detail in the executive order, but the bottom line of what is prohibited is outlined in this particular one, that an individual, by virtue of his or her race or sex, is inherently racist, sexist, or oppressive, whether consciously or unconsciously. Now, the consciously or unconsciously language in here sent alarm bells across every federal contractor in the United States, because many of them have, as a result of the recent protests and BLM, gone into much more intensive race-focused training and town halls and that type of thing, and are using some of these. Implicit bias is definitely one of the things many people use. And in fact, David, as we know, the OFCCP, and we'll talk about them in just a second, has required implicit bias training as part of conciliation agreements as recently as the last couple of weeks, and that they believe that implicit bias training is allowed. And we'll talk a little bit more about what that means. Two other items that are mentioned specifically are race and sex stereotyping and race and sex scapegoating, which are defined, and basically it's the idea of assigning or blaming certain races or sexes for the situation in America, basically. And though that is a very high level of what the aspects of 13950 are. And any other thoughts before we move to the next slide, David?
No, let's keep going.
No, I don't think so. Let's keep sort of going with this, because I think for those that may not be aware of this, these developments are very significant. Right.
So what does this mean for federal contractors? Well, it means, and we're going to talk about this, the OFCCP has taken the position that federal contractors are already prohibited from using workplace training that violates 11246. What that means is that training that discriminates against any race or sex is prohibited already under 11246. Beginning November 21, 2020, new or modified contracts that are entered into by federal contractors have the following requirements. You have to ensure that the training, the D&I training you do, doesn't include these prohibited areas we were just talking about, divisive concepts or race or sex stereotyping or scapegoating. There's an obligation to flow this down to subcontracts and purchase orders. You have to give notice to your union if you have one. And there will be a workplace posting, as we always have with these kinds of obligations. And so there's a lot more detail, but basically you need to look at your training now to see if you have anything that might violate 11246, and also think about the divisive concepts and determine whether or not anything you're planning on doing might violate the additional requirements of 13950 after November 21.
Nita, one thing I just add on the new obligations that come in on November 21, we understand that those would require amending the federal acquisition regulations, or the so-called FAR rules. Correct. And that would occur sometime after November 21. We've been in touch with several members of the FAR Council, and they're still having so-called listening sessions and trying to get their arms around it. This was not a orchestrated effort by the
Correct.
executive branch. This came out of the White House, frankly, and I think caught many of the program agencies, including all the procurement agencies, flat-footed. So they're having to catch up on that.
Right.
If I could just note, FAR Council traditionally are sticklers for detail. They're like the old OMB in terms of they're like your green eyeshade types. And the notion of a divisive concept has probably got their head spinning, because I'm not sure they know what it is, and I'm pretty sure they don't know how to define it. And to reduce it into a FAR reg is a daunting challenge. Right. I don't know what they're going to do.
We will see.
Well, David, let me do one more slide, and then I'm going to pass it on to you. But let's go to the next slide. So what we have learned, David and I were on a call with OFCCP Director Lean. We'll talk a little bit more about that in a minute. But what Director Lean has indicated, and what is in the FAQs, which we'll talk about as well, is that promoting racial, cultural, or ethical diversity or inclusiveness is not prohibited, provided it complies with the executive order. In other words, don't pick on one race or sex. That's the bottom line of what we said. And Director Lean made it very clear that he believes...
Right, you cannot have discriminatory training, is effectively what
Correct.
they've said.
Can't pick on one group. Yeah. Right. And Director Lean said that he thinks that implicit or unconscious bias training is within the limits, as long as, back to point number one, you're not you're not discriminating or picking on one race or gender. And that's the bottom line. Now, what that means for your individual training is another issue altogether.
Yeah, one concern is this another way of saying they're good people on both sides? And that's the fear that many contractors have.
Right. That's exactly right. But it is one that is, and there's much is really unclear at this point. What does training mean? Is it the formal training materials? Is it employee resource groups? Is it informal training? What is entailed in this? What are the restrictions? What if people have conversations following training that address these issues? It's not clear, and but those issues are slowly being sorted out. One of the things we're involved in hosting a town hall meeting this Thursday. That would be the 22nd of October with Director Lean. It's a public town hall meeting, and anyone needs more information, get in touch with us or look on our website. We be happy to have you. Well, let's talk a little bit. So we've got this order out there, kind of came out of the blue. It's about as clear as mud on some of these things. It's raised a lot of fundamental questions. And so let's talk a little bit of what are the agencies doing? Are they getting everything laid out and then they're going to start orderly enforcement? No. Let's talk about what enforcement has started. And on the next slide, OFCCP has immediately, in almost record-setting time, less than 7 calendar days after the executive order was issued, OFCCP propped up a hotline. And they published the hotline. The information's there. And the idea is that individuals or anyone, any interested person, can call the hotline with comments, complaints about their diversity and inclusion training. As of about, a little over a week ago, OFCCP had already gotten over 60, approaching mid-65 at that point, complaints and comments on the hotline. Apparently, we're not privy to what is on there, but as described to us by those that are, a number of the inputs were people on rants complaining about different things, but at least what was described as a handful constituted what the Labor Department felt were legitimate complaints. What does that mean? That means that the OFCCP formally opens a complaint investigation. So they begin looking at what training was conducted, what training occurred, who said what are the materials, they go forward. I would add that also OFCCP has a memorandum of understanding with the EEOC, which means that matters can be shared with the EEOC. So although OFCCP has certain authority with respect to if someone's job has been terminated, restoration with back pay, and potentially the big club, of course, is debarment of federal contractors, the EEOC has additional remedies on behalf of individuals, including both compensatory and punitive damages. So where this goes, what the impact is of trainings that are deemed to be illicit under the executive order, and whether there are trainings that are violative of this executive order are actively being sorted out. So this is one of the reasons that the anxiety level among employers has grown dramatically since this was introduced. And Bert, there are other developments also.
Yeah.
It's not quite a benign.
If we could go to the next slide, this was a shot across the bow of a most unusual kind. Some of you probably saw that a couple of senior executives of some very large and prominent companies came out and said, we're going to do better. We're going to get 20% of our executive staff or 30% of our managers are going to be represented from usually non-representative groups. You have probably heard similar comments regarding we're going to do more women on, we're going to have 20% of women on the board, we're going to have 40% this, that, and the other. These are kind of public PR statements that have been coming time out of mind for most of my life. Well, these two, particularly Microsoft and Wells Fargo, got threatening letters directly from the director of the OFCCP saying, we're concerned that your effort constitutes a kind of implied quota. I mean, mind you, this was nothing but a public statement. This was a PR activity. And they got this, tell me more, implicitly threatening an audit, implicitly threatening an investigation, simply on a public statement regarding an effort to increase diversity in the upper management ranks. He raised a concern that would be fine if it were part of a goal in a utilization analysis as part of an AAP. But, you know, that's just kind of trying to cram this square peg into a round hole. This was clearly a PR statement. The response was rather stunning from the corporate universe, and Secretary Lean indicated that the company's responses were adequate, and he backed down a bit. But the whole idea that it's kind of like what the Justice Department has been used to mount cases against the so-called enemies. And it fits into the pattern that we've seen just this past week of filing suit against Princeton because it published a self-analysis of its history of racism going back to the 18th century. And Bart, please go ahead.
Sensitive to our time. So in addition to these two companies that just signed consent agreements and agreeing to them being challenged by OFCCP, Nita, what other future actions is OFCCP going to be undertaking?
Well, let's go to the next slide. But one thing I did want to mention as we go to the next slide is that Director Lean did mention in our discussion with him last week that he is concerned about compensation tied to meeting certain goals. And so employers should take care as to how they tie compensation to increasing representation. He also indicated we're going to have a lot more FAQs. We haven't seen them yet. There have been some issued. On Thursday, the day of our town hall, we are going to have we expect OFCCP to issue their request for information, which is voluntary, asking federal contractors to submit to OFCCP copies of their training so they can get educated and possibly sue you, who knows, and certainly investigate. They are investigating complaints, and one thing to understand is, at least what we heard from Lean, is that they consider it a complaint if someone feels like their feelings were hurt. That might be a little bit, but seriously, that kind of thing will be investigated. So we recommend you set up something internally to allow them to vent internally before they go to FCCP. No regulations will be issued, and David, you already talked about the FAR. Anything else, David?
No, I think there's a lot going on that OFCCP has, and then the next slide, corporate America has been jumping right into this and not viewed this as a nothing. Interestingly, Starbucks opened by saying, you know what, we're doubling down on what we're doing. We're not only going to set goals, we are going to hold people accountable. And if they don't make the goals, they're going to it's going to hit them in the pocketbook. This is exactly the linchpin on which OFCCP directed its investigation at Microsoft and Wells Fargo. The response from Starbucks basically is, come get us. We're doing exactly the same thing. We think it's legal, it's long-standing, and it's effective. Next, the business community generally, in a letter by the U.S. Chamber of Commerce that represents 3 million businesses, and the Chamber's letter was joined by 150 additional organizations of all stripes, basically it's saying to the White House, you should withdraw this executive order. This is an ill-conceived executive order. It's causing confusion, costing money, and it's not doing anything to promote the advancement of EEO and affirmative action, which is what should be occurring. Finally, the Business Roundtable came in. They were not only signatories to the U.S. Chamber's letter, but they put out their own detailed initiatives, doubling down on the importance of considering racial diversity and goals and holding people accountable, including focusing on the leadership of companies. So a really overwhelming response from the business community of all shapes and sizes, telling the White House, back off. What you're doing is not the right approach. It is not well received, and we're not going to change, because most companies have pivoted and embraced these types of diversity programs in a very robust fashion, particularly in response to Black Lives Matter. And it's clear they are not willingly going to back down simply because the White House is so set. So it's become a bit of a Donnybrook, and I think there's going to be more coming. Well, let's take a few minutes and any closing comments on the diversity and inclusion training developments, Bert or Nita?
The only thing that I find very troubling is the kind of weaponizing of the OFCCP in the way that we've seen other agencies being brought to task to carry political water. And it's encouraging to see the people who have been sponsoring D&I for the last 50 years are saying, we're not going to stop, but it's going to be a real fight.
Yeah, it is an amazing reversal by the administration that started off by saying that OFCCP should be terminated as an agency, simply eliminated, to now, as Bert says, weaponized and put on the tip of the spear on a very controversial initiative. So, strange times. All right.
So, David, one last thing, David, before we go, is what does this mean if we have a Trump 2.0, as you call it, a re-election? What does these kinds of responses, what do you think they are likely to do? And I think we'll just have to wait and see. Come back on November 9th and you'll find out.
We'll have to wait and see, but they will continue. I mean, on a broad basis. All right. Well, let's talk a little bit about what some of, because it's not just OFCCP. The rest of the executive branch continues to move, and frankly, to move at sort of an accelerating pace. Some suggest it's because many in the executive branch, many of the leaders feel that their horizon may be limited to January 20th, and there's a lot of so-called midnight or 11th hour efforts underway to try to get things done. But there have been some other developments too. Bert, do you want to talk about the first one for us?
Yeah, sure do. I apologize to some of you. This is kind of inside baseball. This is a case that's really about the methodology that the OFCCP uses to do its compensation analyses. It's been going on, believe it or not, since the closing hours of the Obama administration. This was one of those 11th hour lawsuits and has been opposed bitterly. But we finally have a decision, and the decision essentially said that the methodology used by the OFCCP to aggregate people for statistical analysis of compensation and the statistical methodology is simply wrong. It did not demonstrate that there had been any discrimination, and even more significantly, it didn't show that there was any non-discriminatory base for any of the challenges to the compensation system. One of the most important findings that the judge had was that the methodology used by the OFCCP did not even attempt to reflect the compensation system used by the contractor, which has been one of the key points in this battle, and frankly, battles of contractors with the OFCCP for years. If there's a takeaway, it's that this decision, and there's an earlier one called Analogic, may cause the OFCCP to rethink what's called the human capital theory, which, you know, is a kind of self-fulfilling prophecy. You use certain factors and it almost predetermines the outcome. This decision and the other one before it were so definitive, so complete. As I say, a 300-page decision from an ALJ is quite uncommon. And there is the hope that the OFCCP may finally take the message that's in some of their directives to try to analyze compensation systems so that they're looking at the compensation system of the contractors. OFCCP has asked for an extended opportunity to appeal, and it remains to be seen if they'll follow through with that. But this is an occasion for some self-reflection from an agency that, quite honestly, is otherwise engaged. So we'll see what happens in the ensuing weeks.
OFCCP, as Bert mentioned, has now taken 2 cases to litigation under very radical theories of compensation, systemic compensation discrimination, and it lost both times before Labor Department, before their own administrative law judges, in very detailed decisions. Many in the employer community hope that at long last, OFCCP is finally going to, frankly, start following the mainstream law. In this case, Janice Madden, the expert that the Labor Department opted to use, had been rejected by 6 different federal courts as being an inappropriate expert for these types of claims, finding that her theories on human capital, as Bert mentioned, were not grounded on the law and should not be relied on. So it was a radical Hail Mary type litigation. It was fought in a very bare-knuckled fashion with lots of highly critical press releases of the contractor. So any suggestion that this administration has been sort of soft on contractors, trust me, if you talk to Oracle, they would take great issue with that, because they've been treated very very high profile public statements when filings were made, and very personalized challenges and attacks on individual executives of this company, and all of that has been totally rejected, and I might add quite appropriately so. All right. Well, what else? OFCCP has now lost two big comp cases. Nita, what else are they up to?
Well, they've been really busy. As you mentioned, a lot of these agencies are trying to get stuff out before the election. They're expected to issue final religious freedom regulations. There are a lot of concerns from employers about what these freedom regulations will mean and what impact they might have on their obligations to do accommodations. They also announced last week that they're going to be doing new AAP and D&I focused reviews in 2021. They will put out a supplemental CSAL list, and this would add, this would be the 5th focused reviews, because they've already announced the accommodation and promotion focused reviews next year. And finally, the AAP verification proposal comments are due they're due next week, as a matter of fact, or in a couple of weeks. So lots going on with the agency.
Right. And of course, a lot of that could change depending on the election. Particularly what happens, what the reviews are in 2021. All right. Well, Bert, let's check in with EEOC because there's been some developments there.
Yes.
Too.
You have been hearing about this for the last probably 5 months, and we can finally put a period at the end of the sentence. The EEOC finally has a commission. Keith Sonderling is sworn in. Jocelyn Samuel is sworn in. Andrea Lucas has been confirmed. There's some bookkeeping but we're going to have a full commission for the first time in a long time. And whether this changes anything remains to be seen, but at least we now have a commission that can issue new regulations, can issue new guidances, can be approved by a full commission. They have a quorum at last. And one of the things they've just done is kind of important and kind of interesting. One of the most often criticized elements of the EEOC is a conciliation process that was neither a process nor did it lead to much conciliation. After a very long process, including a 6-month trial run, public meetings, and things of that ilk, the Commission has issued a proposed rule for a new conciliation process, a very short 30-day comment period. But to give you a sense of how bad things were before, listen to the kinds of things that the Commission is proposing that it must do. A summary of the facts and information that the Commission relied on to reach its probable cause finding. That wasn't done in the past. A summary of the legal bases for finding reasonable cause and an explanation of how the law was applied to the facts. That wasn't done in the past. The basis for any relief sought, including calculations underlying the conciliation proposal. And finally, and this comes right out of the CRST case, identifying whether there is a class and who's in the class. All of those things had been sought by charged parties and had never been given. It's usually a take it or leave it. We want $3 million. That's going to change, we hope. We think this is nonpartisan. We think this will be approved, and we think it will be retained even if there's a change in the administration. Finally, there is amendments to procedure rules, again, non-controversial. The EEOC has been doing some good work, and they ought to be acknowledged for it.
Okay, and I just would note that those new commissioners, their terms will continue even if there's a change in administration. They are confirmed for a fixed term, so they do continue. All right, jump to the next slide quickly. In the closing minute or two, I'll just wrap off a couple of other items to make sure they stay on your radar. The first is the Labor Department's Wage and Hour Division has issued a proposed independent contractor rule. This is very important, so-called for gig workers. There will be a real effort to get, they've offered a very short comment period of 30 days. They need that short of comment in order to get the rule finalized and published before January 20th. Prediction, not a bold one. They will get the rule done and it will be published before January 20th. OSHA continues to be the point of a lot of contention. It has been issuing some stepped up fines. It has changed the reporting period on developments there, and anyone involved in OSHA compliance needs to be mindful of some of the changes that have occurred. 8 hours after to report a fatality of workplace COVID, that's very hard to do. 24 hours to report a hospitalization of, again, workplace COVID. You still have the challenge of determining whether an individual who suffers from COVID, even if they're hospitalized, whether they did or did not contract it in the workplace. Often very challenging to do. All right, well, let's in just a very brief moment on our key takeaways from today. Nita, 10 seconds on each.
Well, I think, all right, COVID resurgence challenges the economy and Congress, and employers struggle with the new opening as they try to reopen with the COVID surge.
I'll pick up where I left off in the slides. The election seems to influence everything that Congress is doing. Obviously, we have a Supreme Court nominee that will be confirmed and change the dynamics of the court.
The Trump administration completely blew it on thinking that the business community would roll over and accept what is obviously a political ploy to reach out to the white male voting population, and are just getting hammered as a result. That's likely to continue. Nita.
OFCCP has to figure out how they're going to handle a second rejection of their compensation analysis and move forward on pay discrimination cases. David?
And finally, I think we're going to get the midnight regulations by great number. However, if there is a change in administration, we'll get no legislation from Congress.
Terrific. All right. Thank you, Bert. Thank you, Nita. And folks, we are going to plan to reconvene with you on November 9th. We're hoping at that point that we will have an election result. If for some reason we don't, which I guess is possible, we will push that out a little bit because we'd like to have the election results in hand so that we can talk about what that means as well as other developments. But with that, we will wish you all goodbye. Thank you again for joining us.
Thank you, folks.
Stay safe.
Stay safe.
Social distance. Wash your hands. All right, Valerie. Thank you.
We would like to thank you for joining us. As a reminder, all registrants from today have been registered for future briefings, and you may view this briefing as well as our previous COVID-19 weekly briefings on our website at www.FortneyScott.com. The next monthly briefing will be November 9th. Be on the lookout for additional updates, which will be sent via email. Later today, you will receive a survey requesting feedback for today's presentation. You are able to submit suggestions for future topics through the survey. Thank you in advance for completing this survey. And of course, if you have any questions, you may submit them via email to info@FortneyScott.com.